Well, I'm going to deny the plaintiff's motion to compel. The defendant has now provided responses. I've reviewed the pleadings that Mr. Canal has filed. His ongoing concerns about those responses, at least his written pleadings, are frankly fairly verbose and unfocused, making it difficult for me to actually understand whether those responses are deficient and what a proper response would be. As I said, this is a FOIA case, and although good afternoon, continuing on the record in the 53rd Circuit Court for the County of Sheboygan and providing public access both in the courtroom and also online. Up next, we have Canal v. Sheboygan. It's file 25-9174CZ. And Mr. Canal, you want to turn your video on here, sir, and confirm your presence?
Can you hear me, Your Honor?
I can hear you. I'd like you to turn your video on.
I thought I did it. Is
there
it
we
on?
Go. All right.
Oh,
yep.
All
right, Mr. Canal, you are representing yourself in this matter, continuing, is that correct?
Yes, Your Honor.
All right, counsel for defense, you want to state your appearance, please?
Yes, Judge. My name is David Bryce, B-R-Y-C-E, with McGraw Morris Massoud on behalf of the City of Sheboygan and the other named defendant in his official capacity.
All right, thank you. And I note we're scheduled for a final pretrial on July 20th. Mr. Canal, this is your motion to compel. When you filed the motion, it was because defendant had not yet provided responses to your written discovery of interrogatories and requests for production of documents. They have now provided a response. I take it from your supplemental pleadings that you find those responses still unsatisfactory. Is that right, Mr. Canal?
That is true, Your Honor. I have also have a statement I would like to read with the court's permission.
Well, about what? I'm here on a motion, not just random statements. So what's your statement pertain to?
It's based on the motion, Your Honor, and what I'm asking.
Yes, so I'm going to ask you to kind of summarize why you think that's unsatisfactory and what relief you think I ought to fashion. So go ahead and make your argument.
Thank you, Your Honor. Plaintiff served formal Wave 1 discovery requests on March 10th. The original court rule response deadline was April 7th. Plaintiff granted defendants a professional accommodation.
Mr. Canal, yes. Hang on. I'm going to interrupt you there and assure you I have read the stuff that you submitted. So to the extent you're about to read written stuff that you gave me, that's a waste of your time and mine. I read the stuff that you submitted. And also, the fact that they didn't file the responses is not very interesting to me because they have now filed. So there's nothing I can really do for that. I'm not going to craft any like retroactive monetary sanctions. These are pretty extensive discovery requests. They've provided a response. What I want to know today, what do you want me to do for you today? So in what way do you think that their filed discovery responses are insufficient and what you want me to do about that? That's what you should focus on.
Yes, Your Honor. Sorry. The defense provided a large production of 446-page production, and the large production is not the same as usable discovery compliance. Many pages appear to be my own FOIA request, appeals, correspondence, minutes. Plaintiff still needs to know which Bates pages answer which request, what is complete, what is withheld, and what does not exist, and what was not searched. I'm asking for complete supplemental Wave 1 discovery response, a date certain, request specific bait mapping, complete interrogatory answers, no record or complete misstatements, a privilege and withholding log, and search methodology. I would also like custodian and system identification, production or identification of non-privileged record count, review or relied upon for the first FOIA fee estimate. The defense continually tries to use some federal case as a shield to discovery, and the discovery standard under MCR 2.302 Bravo 1, the discovery standard is whether the requested information is non-privileged, relevant to the claims or defense, and proportional to the needs of the case. Factual overlap with another lawsuit is not privilege. A record does not become protected for the state case discovery simply because it may also overlap somewhere else. Defendants are
Sure.
also.
So I have a question for you about that. The relevant to the claims and proportional to the needs of the case. This is a FOIA and Open Meetings Act case. You're suing the city and the clerk in her official capacity, saying that they have violated the Freedom of Information Act and that they have violated the Open Meetings Act in various respects. So your discovery, it seems to me, should be laser focused on information to prove those claims. Even frankly, Mr. Canal, my cursory review of your actual discovery requests, it seems to go far afield of those claims and kind of get underneath them to all the stuff you want to begin with, and to complain about action that the city took or didn't take regarding certain criminal complaints that you were filing. But that's not what this lawsuit is. This lawsuit is, did they violate FOIA? Did they violate Open Meetings Act? Am I wrong that your discovery goes beyond those issues?
My discovery is focused on the first request itself. It even states that within the documentation when I applied that FOIA that it isn't for a federal lawsuit. I wasn't going to pay the fee when it was inaccurate and deficient. And
Okay,
I'm
go ahead
merely asking, oh, sorry, Your Honor.
Go ahead with your argument.
I'm merely asking for that documentation, because without that documentation, I can't assess the FOIA production without knowing the information that was being produced.
Can you describe for me in some, kind of way that makes sense, human to human communication? Tell me now, as a person, what information do you need from the city about that you're not getting?
The actual FOIA request itself, the
What do you mean,
300
the
and
FOIA so what do you mean the actual FOIA request?
the first FOIA request was documented as 300 and I believe it was 346 pages of documentation.
Okay, so this is your request that you made to them, you're saying?
Yes, Your Honor.
Don't you
That's
have
what-
that?
No, Your Honor.
Why don't you have copies of your request?
I have the request itself, but the
Okay.
information they were going to provide to me isn't provided.
Well,
The
yeah, that's the
FOIA
subject of your lawsuit. That's the subject of your lawsuit, that they haven't given you that information. All right. Anything else I need to know to understand your position, Mr. Canal? All right. Hearing no answer to my question, I'm assuming that's a no. Mr. Bryce, what's your response?
Well, Judge, thank you, Judge. The main thing I'd say is I believe I heard Mr. Canal say that with his motion here, he's trying to get the documents that he FOIA'd. And as you correctly pointed out, that's the subject of the suit. And there is a case that speaks directly to this, which is Arabo v. Michigan Gaming Control Board. It's 310 Mich. App 370. And that case was dealing with a protective order, but conceptually it's the same. And what it says is that a plaintiff can't get the same FOIA documents in its FOIA lawsuit that it was trying to get via FOIA, because that would just do an end around, in so many words, an end around FOIA. So what's happened here, Judge, is the city assessed fees, and Mr. Canal has not paid those fees, and that's really, aside from the Open Meetings Act, perhaps there's a different wrinkle there, but as to the FOIA, that's really the only issue at hand is whether the fees themselves were properly charged. When a deposit is required, which is what occurred in this case, there's not even a final determination until the fee is paid, the deposit is paid, and then the request is processed. That hasn't even happened. We're just at the fee stage. And so what I would say is the city has provided, almost 500 pages, everything that he needs, that we have, would be a better way to put it, that goes to the issue of how the fees were determined or anything relating to the actual FOIA request that we've produced.
All right, thank you. Mr. Canal, your any rebuttal argument?
Thank you, Your Honor. There's two things I'd like to address. One, a large production is not the same as usable discovery compliance. Many of the pages appear to be, like I said, my own FOIA requests and emails that I sent. As per the fee, this is civil discovery, not a new FOIA request. Defendants used alleged response records to calculate and defend the dispute fee estimate. Plaintiff needs the non-privileged record they identified, collected, reviewed, counted, and relied upon to test the search, the fee estimate and burden claim, and the appeal handling.
All right, thank you. Well, I'm going to deny the plaintiff's motion to compel. The defendant has now provided responses. I've reviewed the pleadings that Mr. Canal has filed. His ongoing concerns about those responses, at least his written pleadings, are frankly fairly verbose and unfocused, making it difficult for me to actually understand whether those responses are deficient and what a proper response would be. As I said, this is a FOIA case, and although discovery has been granted, it seems to me any necessary discovery would be fairly limited to information about the FOIA request and the city's response, not to dig underneath it and say, so you have to give me all the stuff that I had requested. Also, there are Open Meetings Act claims. Again, discovery should be focused on any alleged violations of the Open Meetings Act. Even a cursory review of the plaintiff's discovery request reveals that they go far beyond that scope. So under those circumstances, I'm going to decline to grant any relief at all to plaintiff on this motion. The issues in this case should be fairly straightforward and focus like a laser on the Open Meetings Act and FOIA claims themselves. So the motion to compel is denied. Discovery has been responded to, and we're scheduled for a final pretrial on July 20th, and then we'll proceed to either any dispositive motions that the parties may have, or to trial as the case may be needed. All right, so Mr. Bryce, as the prevailing party, I'll ask you to submit an order.
Yes, Your Honor.
Okay, thank you both very much. Have a good day.
Thank you, Your Honor.
Thank you, Judge.